SJC-12760, Green Mountain Insurance Company, Inc., v. Administrator of the Estate of Dana Lee Powers and others.
Thanks.
Would you wait for a moment for your brother? All right, Mr. Harris, you may begin.
Thank you. May it please the court. Ladies and gentlemen, my name is Brian Harris. I represent Green Mountain Insurance Company. Green Mountain is the appellant in this current proceeding. As of 2015, Green Mountain provided insurance coverage to an individual by the name of Mark Wakelin. That particular policy limited coverage to property which Mr. Wakelin owned in Braintree, Massachusetts. Unbeknownst to Green Mountain, Mr. Wakelin also owned property in Byron, Maine. This was a cabin up there that was off the grid. It didn't have town-supplied water. It didn't have town-supplied electricity. Green Mountain did not know of this cabin's existence. Green Mountain never had an opportunity to perform a risk assessment with regard to whether and how to provide coverage on this property.
So you'd say you never even get to the arising out of issue, because they don't even know about the premises.
If we are to interpret that exclusionary language strictly, Your Honor, then we don't even get to that issue.
Am I correct in understanding that if we held for your brothers, that we would then essentially be creating a rule where wherever that generator went, you would be on the hook for liability for whatever trouble it caused?
That's what the appellees
I'm sorry, yes.
That's what the appellees are asking this court to decide, and they're using the First Circuit Court of Appeals case, the Zamsky case, in support of that. And it's our position that that doesn't apply in this case. That, and I'm assuming that the courts know the fact pattern in the Zamsky case. The fire pit in the Zamsky case is completely different from the generator in this case. The generator in this case provided a service, a function to the property. It made the property, the main property, more livable. It made it more comfortable. It provided electricity.
Can you refresh my memory? Was that generator stored somewhere else usually?
No, Your Honor. The generator was purchased by Mr. Wakelin in 2012. From that day up until the time of this incident, the generator remained in one place, in one place only, in the property in Maine. In fact, that generator was chained down into the basement. It was never moved off the property.
But it could have been moved, though. This is a hard case, right? I mean, because you do have, for example, if you move that generator back and forth between places, wouldn't it be pretty much like the Zamsky case? This is close, right? Because you have personal liability. If it were a fire pit and you moved it back and forth, you'd have liability, right? That one of those portable fire pits?
That's what the Zamsky court said, Your Honor, and we're distinguishing between those two things.
But this is hard, right? Because, I mean, it's right in the gap. And to me, your best argument is that this place doesn't run very well without this generator. The premises itself is dependent on some kind of electrical power source.
Agreed, Your Honor.
That to me may make this different, but that generator is totally portable and could be moved around, so it's hard.
Agreed, Your Honor.
I don't see how we got to wrestle with the facts of whether that, I don't think, this is a personal liability seems to be accepted in the industry, so it's really whether this thing is different, right?
Well, I will agree, Your Honor, that this is a unique fact pattern. It's one that a law school professor would have loved to have given to a student. It's that unusual. However, the fact remains that a fire pit in the Zamsky case is different from the generator here. The generator in this case provided a service, a function to the property. It made the property more livable. It changed, it impacted the character of the property.
What do we do with Mr. Wakelin's testimony that he only used it to power his power tools, and the fact that he was up in Maine living off the grid was he was up in Maine living off the grid, and every now and then they would plug the microwave in when it was on. Other than that, he basically made it seem more like the fire pit. So what do we make with that testimony?
That's Mr. Wakelin's testimony. However, after the tragedy occurred, the police arrived at the scene, and they determined that the refrigerator had actually been connected to the
Yeah, because I assume
generator by
I
an
assumed the
electric cord.
kids tragically attached the fridge to it and obviously didn't ventilate and kept it in the garage. But do we go on what the kids did, or do we go on what Mr. Wakelin did, who was the policyholder?
I don't think we can discount either, because both, if this case were to go to trial, the testimony of both would be introduced into evidence, and the fact finder would have to make that determination. The fact remains that in this instance, the generator was used to provide a function for this property. It
I
made the-
guess the point of having a refrigerator is it's an electric refrigerator, right? So that's
Correct,
So you would
Your
draw an inference that the reason he has a refrigerator is to keep stuff cold, and he needs the generator for that.
And that wasn't the only electrical product or product requiring electricity on this property. There was also a stove, there was also lights. So irregardless
But
of
we
what.
also, but I agree with that. But if we look at this in a more simple way, it's summary judgment, and we're looking at it in the light most favorable to the non-moving party, not the light most favorable to the moving party.
This is as this court knows, this is a de novo process. The court's being asked to look at the facts for the
But what I'm
first time.
saying is, we still, it's summary judgment.
It is, Your Honor.
No, summary judgment never answered for anybody, right?
I'm sorry?
No, there was no summary judgment ended for anybody, right? You were denied it.
We submitted cross motions for
Oh, it was
summary
cross
judgment.
motions. It was
In
cross
August of
motions.
2018, the lower court denied our motion.
Did it grant the cross motion?
It did.
Okay.
The court did.
But there are no disputed facts here, are there? I mean, we know exactly, like that refrigerator was a little college-type refrigerator, right? It's not or do we not know that fact? It's not one of these, like giant.
What we
regular
know is the refrigerator was a piece of equipment that required the use of electricity to power it. That
Right,
it didn't matter. It had no practical purpose unless it
But I
was
thought it
powered by
was.
electricity.
No, I understand that, but as Justice Gaziano pointed out, it's sort of like, from what I understand, was this refrigerator brought by those kids?
No, the refrigerator had been on this property since the property was first owned by Mr. Wakelin.
And am I misremembering? It's described as like one of these college-type refrigerators, one of these little.
It may have been, Your Honor, and yet it's a piece of equipment that required the use of electricity to use.
When we look at we have to look at the premises, right? So is our focus on the fact that there's no electricity in the premises, or is it on the generator itself, or both? Because it's not that it occurs on the premise, it has to arise out of the premise, right?
That's the language in the exclusion policy, but our appeals courts, in trying to interpret that arising out of language, said that it has to be a condition of the property, and the assumption is that the fire pit was not a condition of the property.
Right.
It didn't further the property.
Right, I understand that, but the condition of the property is that it has no electrical power.
Agreed.
So it has no electrical power, but it's the winter, you need some electricity, and that thing never moves, so.
Agreed, Your Honor.
So maybe that's your best argument, that.
It's a fair argument, and it's one of the arguments that Green Mountain's making, and what we're saying is that the generator, this gas-powered generator, is a condition of the property. It provided a function to the property, whereas the fire pit may have provided value to the property owners. The generator actually provided value to the property itself. It made the property more livable.
Could I ask you a question? Does it change really if property did have electricity? Because people use generators, even though properties do have electricity, because electricity can fail, right? Be a bad snowstorm, wires can come down.
Yeah.
And so you have a generator, and somebody can be foolish enough to do what the children here did, which is to put the generator inside the house, which you're warned never to do. Does it make a difference if, in that
I don't think-
hypothetical?
I don't think it does, Justice. Once the generator is being used, it provides a function to the property. It makes the property more livable.
Right, so the fact that it was a house that didn't have electricity didn't really make any difference?
I don't think it does.
Okay.
I don't think it does, Justice.
Can I ask about the ruling? We have to read ambiguous provisions against the insurance company, right? How does that work here? Is this language ambiguous, the meaning of arising out of the premises, or is it not?
The lower court, Your Honor, in its decision said there is no ambiguity. What the lower court said, and this is consistent with case law, is that even though there might be a dispute as to language in a policy, two different interpretations, that doesn't render it ambiguous. And the lower court said there's no ambiguity in this arising out of language.
Well, I don't care what they said as much as what you interpret it to mean. What do we do with the fact that this is hard to figure out what arising out of means? Because a lot of smart judges are wrestling with what that means.
This court, back in 1999, issued the decision of Bagley versus Monticello Insurance Company. In 1999, this court interpreted the arising out of language, and it said that it should be interpreted as expansively as possible, and it's more like but-for causation rather than proximate
But
cause.
that was in the inverse situation, right? That's when we're dealing with coverage. Is that right?
It was a coverage case, correct, Your
So
Honor.
we interpret arising out of broadly when it's coverage, but you're asking us to interpret arising out of broadly to benefit the insurance company. Is that a different situation?
I don't think, Your Honor, it's consistent with what our appeals courts decided both in the Callahan case, which involved the dog bite, and in the Theodore case, which involved a tree and someone trying to cut the tree and the ladder fell off. In the dog bite case, the court said the exclusion didn't apply. In the Theodore case, the court said that the exclusion did apply. Following up on that, on the Bagley case for a second, Your Honor, a few years before that, this same court said in the Pappas decision that this court, has an express interest in making sure that they follow, to the extent possible, language, that they follow other jurisdictions in their interpretation of the exact same exclusion provision language. And every homeowner's insurance policy in Massachusetts and every homeowner's insurance policy throughout the country, this same exclusion language exists. And in the Supreme Court in Connecticut, in a dog bite case, said the exclusion existed when a person was bitten on uninsured property. And in New York, the Court of Appeals, their highest court, also said that the exclusion.
We've said the opposite.
I'm sorry?
We've reached the opposite conclusion, right?
No, this Supreme Court's been silent on this, and I think that's why the Zamsky Court asked at some point that this Supreme Judicial Court weigh in on this issue.
We've said dog bites. If your dog bites you, we reach the opposite result.
Correct,
right?
Your Honor. And our appeals court in 2000 in the Callahan case said that a dog on uninsured premises did not constitute a condition of the property. And that's a perfect example. That dog didn't provide a function or a service for that property. It didn't make the property. It didn't change the character or the condition of the property. And that's a fair distinction because in this case, in our generator case, the generator absolutely changed the condition and the character of the property. It had something to do with the property.
I mean, isn't the way to understand how different courts have decided it is as to whether it's a fixture on the property or not? I mean, the tree is a fixture on the property. The fire pit was not a fixture on the property. The dog is not a fixture on the property. If this were a stove that were a fixture on the property, I trust we'd be in a different posture, but this is not a fixture. It's a portable generator. So how do you manage to prevail where it's not a fixture?
This, and the Zamsky case addressed that issue. This portability issue or analysis is inherently flawed. And the best example is an above-ground pool on uninsured property. It's been there forever. It's huge. But technically, the water could be removed, and this above-ground pool could be moved off the premises. Because of that, it's portable, therefore it's not a fixture.
That just may be a silly interpretation of what's portable, but unless it is truly pool you can pick up if it's truly dug into the ground. It seems to be a fixture. But why should we not simply adopt the fixture versus portability theme as that which is the sine qua non with regard to what constitutes arising out of a premises?
I think it muddies the waters, Justice. I think
Seems
that
simpler,
causes
doesn't it?
more
It
problems.
seems whether it's a
than-
fixture or whether it's portable seems to be a simpler analysis than the more metaphysical analysis you're asking us to employ, isn't it?
I think the courts have the ability, Your Honor, to look at the fact pattern. If the whole issue, if this issue is limited to one thing, it's a fixture, therefore it's not portable, then, again, a rug that bunches up in a living room, it's not a fixture, therefore the exclusion wouldn't apply. But if that same rug was tacked down, then technically it would be a fixture. Those kinds of artificial distinctions don't further this analysis at all.
Don't we run into problems when you have some generators are hardwired, some generators have cables, some generators have extension cords? And now we'd have to determine, we have a separate rule for the extension cord generator and the cable generator.
And that distinction makes no sense, because that focuses on the fact whether or not the generator is anchored into the ground as opposed to its function, what it does, how it furthers the condition
Some
of the
generators
character
are
of the
small, you
property.
can put them in your truck. Some generators are big, not so portable.
I agree, Your Honor, and that's why the fixture argument is inherently flawed, and yet the lower court relied upon that.
Have other courts adopted the fixture, other state Supreme Courts adopted the fixture approach or not?
No, they have not.
So it's not a rule out there.
It's not a rule.
How have other courts dealt with this?
Well, again, the Connecticut court, the
we had the
the
trio.
New York court, the Wisconsin court in 2016,
Johnson, which one is that one?
they handled it very, very simply. They said if the incident occurs on the property which is uninsured, then the exclusion applies. And that really that really satisfies the expectations of both parties. The insurance company shouldn't expect to provide coverage for property they didn't know anything about.
Yeah, but here's the thing, that's not what the policy says. It doesn't say the same thing as the Wisconsin policy apparently says.
I'm sorry, Your Honor?
What does the policy say versus what the Wisconsin court just held?
Oh, in the Wisconsin case, a teenager was beaten up by a third party at a location, an uninsured shed. And in that case, the Wisconsin Supreme Court said the exclusion applies. In that case, the exclusionary language was the exact same in the Wisconsin insurance policy as it is in this is the insurance policy which is the subject of this lawsuit.
And in Wisconsin, they didn't get to the arising out of language. They just said, well, we contracted for what we knew, not for what we don't know.
That's exactly right, Your Honor. They they said it happened on property that was uninsured, therefore the coverage should
Otherwise, how
apply.
do you calibrate the risk?
Well, you don't get to that. You don't
No,
get
I'm
to the
just
issue.
saying, how does the insurance company calibrate risk about things they don't know about?
Well, it's a fair question, and it's one that an insurance company has to address. But if this court adopts that more logical test, that if it occurs on uninsured property, then there's no coverage, then the insurance company has to prove that they didn't know about that.
But that's not the way you wrote you didn't write an occurring on policy. You wrote an arising out of the premises policy. You could have written a different policy. You didn't do that.
Right.
Yeah, and that's what the Zamsky court said, Your Honor. And what's interesting about that, and I don't normally attribute to the insurance industry generosity, but
Yeah.
in that case, had the policy language that said nothing more than if it occurs on the property, then there's no coverage, then that would operate to limit insurance coverage in this case. For example, in the Callahan case, the dog bite case, because it occurred on the property, there would be no coverage. And the appeals court said, no, that's not the analysis. The analysis is if it's a condition of the property, then the exclusion applies. Because the dog was not a condition of the property, the exclusion didn't apply. If that language that you're now suggesting, Your Honor, should be used by the insurance industry, then in the dog bite case, in any case like that, then there would be no coverage because the exclusion would automatically apply.
I understand that, but that's why you sell policies that have personal liability coverage unless it meets that exclusion. You know, the industry, you know, people understand they're covered when their dog goes and bites somebody somewhere else, you know. But anyway, I'm belaboring that.
Well, the thing is that, you know, this has been around since at least 2000, because that's the oldest decision of the trio that the judge cited. I'm surprised that the insurance policy the language hasn't been changed to cover the situation.
It hasn't, and I don't think it will, because the same exact exclusion language is used in every homeowner's policy throughout the country, and it works.
Well, because of the personal liability issue.
Well, no, you don't get to that. You don't get to the issue of whether or not there's personal liability as long as the
But that's the
court...
coverage that the homeowner is buying, right? It's not just property insurance, it's also personal liability
Well,
insurance.
it is. Yeah, Section 2 liability insurance is what's at issue here.
Yeah, I know.
But the court and our appeals court in the Theodore case dealt with that issue and said personal liability will be excluded as long as the incident arises out of the premises.
Okay, thank you.
Thank you, Your Honors.
Mr. Conley.
Mr. Chief Justice, members of the court, good morning. My name is Mike Conley. I represent Charmaine Norris, who is personal representative of the estate of Keith Norris. I'd like to start, if I could, by addressing Justice Cipher's question concerning the nature of the personal liability coverage. Mm-hmm. And it is true that the personal liability coverage covered Mr. Wakelin wherever he was, as whether it's working with a generator or anything else, because that's just the nature of the coverage. Under the insurer's argument in this case is that he would have been covered anywhere in the universe except on that small property in Maine, because working with that generator is portable, it can go anywhere. Mm-hmm. And if it was in some other place, if it was at home, it was in somebody else's house that he didn't own, his personal liability would attach. And so the argument here is that, and I think essentially Green Mountain's asking you to overrule Callahan.
Yeah, I don't really think it's that easy. I mean, he's built a property, he's not paying for insurance on this property. And the premises has no electricity, and this generator basically solves that problem. Now, it's mobile, but is there anything in the record that indicates it's ever been moved?
No, Your Honor. The testimony was that he used it essentially to power up his tools and the battery of his tools while he was working on the place.
Or when when he needs the refrigerator to work, or when he's freezing. You know.
Well, I don't think it's a winter resort, Your Honor. I don't think you could get there in the winter.
But what time of year is this? I've forgotten.
This is, I think it's late spring.
Late spring?
July.
Okay.
Mm-hmm. But, you know, if, for example, he could have had it in his truck and brought it back and forth. I think the presence of it.
The problem is what I'm focusing in on is the premises. The premises is dependent on this for electrical power, and it needs electrical power some of the time. And it makes it a harder case than the fire pit case where it's sort of this luxury item that they move around. When I look at the whole premises, it just seems like this generator sort of is the missing link for electricity.
It did not for Mr. Wakelin. In fact, on page 113 of the volume 2 of the record, when he's asked about this, he says, Daniel Boone did fine, or something to that effect. He was not up there to luxury. He was not seeking to power up his property. And in fact, there was some rough wiring, but the place wasn't capable of being hooked up to anything.
Am I remembering correctly, was there some solar heating?
I think there was some solar-powered outdoor lights like you might find at Home Depot or something like that.
So there's some rough wiring in there with no prospect of the municipality running power out there, correct? Right. So you would assume if there's lights that are rough wired out there, there needs to be an electrical source, which in this case, by nature of the remote location of the premises, would have to be a generator.
If the wiring was ever completed.
Right.
And the building completed, and there was a desire to have a permanent power source up there, he would have to make some decisions, whether to invest in solar, get
And he may be Daniel Boone, but he has this generator in his, inside. He's got it chained up to the garage so nobody steals it with his ATVs, right? When these kids go up there, isn't it reasonable to assume that they're not gonna rough it? There's a refrigerator there, they're gonna have to use the generator.
I don't think that was the assumption at all. In fact, I think there was some suggestion they were told that not to use it. But the question is really more than.
Is that in the record that he told them not to use the generator?
I can't represent that, Your Honor.
Okay.
How long were they staying up there?
My impression was a weekend.
So they got to eat, right? They can't.
Well, yeah, I don't think there was a working stove. There might have been a microwave that could be plugged in.
I'm talking about they got to have food, right? It just seems like the generator, again, is a sort of a necessary piece to staying there for a weekend, right?
I wouldn't agree with that. But I think when we get into the use of a specific thing, when we get into the use of a specific piece of personal property, now we're dealing with an area of ambiguity within the interpretation of arising out of. Because all of the case law, at least unless we overrule Callahan, is talking about features of the property.
By the way, have appellate cases said that arising out of is ambiguous and should be?
Callahan says that.
Callahan says that? Okay.
And so what we end up with, I think, is in using the Callahan analysis, where it needs to be a condition of the property. Now we're out of any sort of guesswork as to what an individual's intention was with his use of his personal property. And we're out of any very complex jurisprudential analysis into what I think is the proper interpretation, which is almost like the Sesame Street analysis of one of these things is not like the other. And in the case law, they talk about holes in the walkway, loose steps, defective plumbing, faulty electrical wiring, loose board, falling roof slate, failure of outdoor lighting, or protective electric fence, which are all features of the property. They're part of the property.
So do you like the chief's approach with the fixture? Is that, you like Sesame Street? Should we adopt fixture as our Sesame Street?
I think it makes perfect sense, and that's outlined in the amicus brief from Mass Academy.
And are there cases that say fixture is, because we are dealing with an industry-wide provision, right? This is across the country around, are there cases that adopt that simple thing, or should we be the first one to do it?
I can't speak to that, Your Honor. I would defer to the amicus brief. I know it was addressed, but I wouldn't make a representation on that. Although I'm not sure there's much of a difference between a fixture analysis and what we're advocating, or Callahan, except that fixture analysis really talks about.
So is fixture the same as condition?
No, because condition is broader in the sense that a hole in the sidewalk is not a fixture. Or
But does it matter here that there was no defect in the generator, and there was no defect in the house? The only defect was the failure to properly inform the guests as to the proper use of the generator.
Exactly, Your Honor. I think that's the problem with the insurer's reliance on this electrical engineering expert to say it was not adequately ventilated. That would be like saying if we ran it here, it's not adequately ventilated. It was a structure with windows that opened and closed. There was nothing wrong with the building that contributed to this happening. So it's right in the personal property realm.
So are we focusing then on whether there is some defect in the condition of the property?
That seems to be the analysis as on the features I just ran through, which are what's enumerated in Callahan. And that's why I think if we look for just fixtures, it's probably too narrow, because a broken sidewalk wouldn't be a fixture, but the physical condition of the property. And I'd like to just
Oh,
finally
so
point
then
out.
you're saying that arising out of a premises means arising out of a defective condition? Present
The
in the
condition of the premises. Unlike, for example, the motor vehicle exclusion where they talk about arising out of the use of the vehicle, this says arising out of the premises itself. On page 26 of the Green Mountain brief, the position is taken that Green Mountain should win because the portable generator is indistinguishable and completely the same as an electric fence, which is posited in Callahan, and it's impossible to distinguish, which suggests that using that analysis argues in favor of coverage because the generator is movable, it's not part of the premises, it's not erected on the premises, it's not a defect in any way. So, Your Honor, I think my red light is on. Thank you.
Thank you. Mr. Doyle?
Good morning, Mr. Chief Justice and Justices. My name is William Doyle. I represent the estate of Deanna Powers. To address several of the points raised by Justice Kafka, it was a college refrigerator, and you'll see that in looking to the record appendix, there will be pictures that will show that it's a college refrigerator that's set on a table. And the testimony of Mr. Wakelin is that he's not even sure that it works, that he used it strictly for storage. The testimony also is that the cabin was wired, but that it was never connected, that Mr. Wakelin at some point in time perhaps would in the future consider, as one of his neighbors had done, install solar panels, but that he had never reached that point. That the Zemansky case, in trying to arrive at a determination of in addressing the fire pits, in addressing the arise out of a condition of the premises, focused on 5 points. 1, easily movable, not part of the premises, not erected on the property, not a defect in the property, and not a condition of the property. I'd suggest to you, in addressing all of those points, you're going to find that the exclusion does not apply in that there is coverage. Green Mountain determined that there was coverage, and now they just want to apply the exclusion to try to exclude coverage. They determined that Mr. Wakelin was covered under their policy, but that they want to apply the exclusion to exclude the coverage. They knew that they wrote a policy that covered him should he push through the Christmas line to buy the hot item for this year's Christmas sale. They just want to exclude the coverage for what happened on July 14th. The testimony was, and the record established, that this camp was used from sometime during the mud season in the springtime of each year to sometime in the fall of each year, but that it was impassable in the winter season. It was unlivable, that it was on a mountain road that was not passable. The electricity for the generator was used strictly for the tools. That's the testimony that Green Mountain cannot get around. That if it was operating the tools, that on occasion, Mr. Wakelin would then use the microwave to heat a cup of coffee. But that's the only other time he would use it. He would not use it for the refrigerator. He would not use it for any of the other equipment. That he would wake when the sun came up, and he would go to bed when the sun went down. That he had solar lights on the exterior of the property, and that in the inside of the property, he had some battery-operated lights, but he had no electric lights inside of the property. That the generator was not used to operate any other equipment inside of that property. It was strictly for the generator for the power tools.
Was
He
the
built-
refrigerator there at the property, or did the kids bring the
No.
refrigerator?
Mr. Wakelin brought that refrigerator many years earlier, back prior to bringing the generator up. I think the record will establish that he bought the cabin, it was part of a kit, sometime in the 2010 time period, and he started to bring things up from Massachusetts. He brought up a slot machine that was never operational, but he wanted to get it out of Massachusetts because he was afraid of somebody stealing it. He brought up the refrigerator, he brought up other things, but they were never plugged in, they were never used.
Bring up food for the refrigerator?
Pardon me?
Did he bring up food for the refrigerator?
He would bring up food, but not that needed to be refrigerated.
I mean, it's hard to sort of accept on summary judgment that the refrigerator was used for storage and not food, right? That's going to be a tough reach. Don't we have to accept that the refrigerator is there to keep some things cold to eat?
It's Mr. Green Mountain had an opportunity to examine the witness. Green Mountain had an opportunity to inspect the house and did inspect the house. Green Mountain had an opportunity to open the refrigerator and look inside the refrigerator. Green Mountain had an opportunity to see what was in the refrigerator. Immediately in the aftermath of the tragedy that took place, there's no indication.
By the way, when I take it someone opened the refrigerator when the children died there, what was in there?
I have no idea, Judge.
I don't know. Okay.
Can I ask you a question? This all arises out of the fact that the house in Maine was owned by the insured, right? If it had been exactly the same set of circumstances, but it was leased, there'd be no problem with the coverage.
There'd be no problem with the coverage.
Yeah. That's
Doesn't
just-
the policy apply to leasing as well as ownership?
Applies to owned or rented to an insured or rented to others by an insured,
Okay.
the
so
exclusion. All right, thank you.
Thank you, Judge. Happy holidays.